Welcome back to the Land Bulletin Podcast, where every other week we bring you experts in the field to impart their knowledge when it comes to the ranch and sporting property market, buying and selling advice, the latest best stewardship practices, as well as topics that impact landowners every day. I'm your host, Hayley. Let's jump in. Welcome back to the Land Bulletin Podcast. I'm Hayley, and today we're going to be going over estate planning and generational ranches with an expert, what you need to know, how to plan ahead, and what to expect when you're kind of considering this next stage of life. Helping me out today is Thomas Mecham of Holland and Hart. Welcome, Thomas, to the podcast.
Thank you, Hayley.
Perfect. And before we go into what we're talking about today, I'd love to know a little bit of your background and how you came to working at Holland and Hart, and specifically how you got into kind of estate planning.
Well, it's something that I really dreamed about since I was about 15 years old, sadly, because my father, that's what he did, and so that's what I thought I should do. But I went to accounting school and then decided I didn't quite like public accounting, and so then I went off to law school in New York. And after 3 years of that, I thought, well, I better get my MBA before I'm out of the habit of cracking the books. So I came back to Salt Lake and began my practice and went to school part-time and finished my MBA at the University of Utah as well. So then I got into the practice of law. I've spent time at 3 different firms, but remarkably, even from the very get-go, I got involved in estate planning. I've used my business degree for business planning as well. Those two kind of go hand in hand together. Most wealthy clients also have a business, which contributes to their wealth. And so having a knowledge of both of those areas has been particularly helpful. But it's something I've done now, perish the thought, for 30 years. And but anyway, I still enjoy it. I like what I do and enjoy helping people solve problems. So,
yeah, and this, we deal with a lot of generational ranches, a lot of families, a lot of, people that are kind of considering what's the next stage, what am I doing for my kids? So this is a very important piece of that kind of planning and helping your family in that process. So before we go into the specifics about how this relates to ranch ownership and how landowners might be affected, what is the best time to kind of start this process of planning, doing estate planning? Do you have kind of a to-do or best practice for the clients that you work with?
Well, everyone can benefit from planning. And of course, none of us knows when we might become either disabled or pass away. And so it's always good to have a plan. And we call that a contingency plan. We're planning for uncertain events, or at least uncertain in their timing. But there's probably a golden period in a farmer's or a rancher's life where they can see they're getting older. They can't do what they're able to do. They're increasingly relying upon the next generation to perform a lot of the functions that they did. And hopefully they're seeing their children and others step up and really learn the art and craft and acquire a love for what it is that they love and have loved their whole lives. And so when successors begin to sort of appear, this is a person that I think it could take over this aspect of my ranching operations. Well, then it's probably a very good time to start putting together that plan. Those plans will vary because family relationships vary, operations vary, the nature and extent of your operations vary. All of that then is something that I try to understand when I first meet with a client. And then what I hope to bring to bear are various trust instruments, wills, buy-sell arrangements in businesses, the legal tools that can help that transition occur. But what I find is it's much better to first understand what it is the client is trying to accomplish before I whip out a bunch of different techniques and instruments that, it's definitely not a one-size-fits-all. And, it involves some very unique personalities. I've lost both my parents over the last 7 years, and I'm the oldest of 12 children.
Wow.
And so managing that traffic has been a challenge. But I certainly recognize the need to be sensitive to the different personalities that are involved and people with different skill sets. And so there's a real art to putting together a plan. But in any event, getting back to your question, when should it be? Well, we always ought to have a contingency plan, but we ought to get real serious about it maybe when we're in our late 50s, early 60s. We really need to have something in place, a plan moving forward.
And, in terms of maybe at the very beginning of ownership, are there things that landowners need to be aware of, maybe even before they get to that age, that might help, like the way they purchase a property, whether that be through an LLC, a trust, those kinds of things, just to be readily prepared for if you do have kids, if you're considering kind of that estate planning route? Not sure if there's a best case scenario for something like that.
Yeah, I mean, much of that planning occurs, every year we reconcile with the tax man, right? We have to file our income tax return. And as we acquire property, we need to consider who the owner of the property is or should be. And there, unfortunately, there are some big mistakes that can occur if you're not receiving good advice at the time. So whereas I might come on the scene when you're in your 50s or 60s to help you develop this plan, much of what you've just described is already baked in, and I have to deal with the puzzle pieces as they're presented to me. But, on an ex ante or going forward basis, if I'm planning with a clean slate in front of me, certainly acquiring land in an LLC form or a partnership form or just a sole proprietorship, a single owner form, or owning it jointly between two individuals, those are all things I can do something with. If you've had the misfortune of putting it in a C corporation or any sort of corporation, you've probably had interactions with your accountant several years in a row where your accountant says, boy, I sure don't like the look of things. And we probably ought to be doing something to fix it. But unfortunately, there aren't a whole lot of fixes in those circumstances, and it can make it complex. So getting good planning all along, and a real good accountant hopefully will know when it's good to involve an attorney. We cost more. We don't need to be involved at all times along the way, but there are certain big decisions where it's super helpful to get good legal advice before you cut the cloth, so to speak.
And we've talked about other tools that may help our clients when they come down or when they start talking to you, and they're considering that path forward. Conservation easements are something that we deal with every day. How do conservation easements, or how might they lessen the burden on families from an estate standpoint?
Strategically, from a tax minimization standpoint, a conservation easement can be quite helpful. And what is going on there is you are looking at the basic transfer tax system. Many of us are familiar with the income tax, again, because we have to pay it every year. We're not as familiar with the federal estate tax, which is a tax imposed upon the so-called privilege, because it feels like those assets are ours. But the government nevertheless tells us, nope, if you want to transfer that to your intended beneficiary, you're going to have to pay a tax. And that's the federal estate tax, sometimes called the death tax. And many are not familiar with it because Congress has granted us fairly generous exemptions against the tax. Currently, the exemption that each individual holds, so a couple would be double this amount, is $13.61 million. So together, a couple could transfer over $27 million in assets and not stub their toe on this tax. But if you find yourself with land typically and other property, plant, and equipment that exceeds that threshold, or if you're single, then it's just the 13.61, then you need to do something. We can think of that as sort of a corridor that you're going to have to squeeze through. Whatever you own, you want to squeeze those assets through that 3.61 hole, and that then can be assets can be minimized by a qualified conservation easement. And what you do there is you take your land and you subject it voluntarily. It's like putting on handcuffs, which you're going to say, I'm going to restrict my land use to this special specific purpose, to ranching. And so we're not going to develop it. And even though development, your property might be in the path of development, and eventually someone may want to buy that to build cabins on or what have you, by imposing a conservation easement on that property, you're restricting it from that particular use. And by so doing, you reduce the value of the property in the amount of the restriction. The value of a conservation easement is the fair market value before the restriction is imposed, and then the fair market value after the restriction has been imposed. The difference there is a conservation easement. That's the value, if you will. You can donate that during life. It can create an income tax deduction, which then shelters the income from future operations. And then secondly, let's say your parcel of ground was worth $40 million before the qualified conservation easement and worth $20 million afterwards. Well, now the only value of land for which your estate is responsible after you've passed away is the $20 million. And that fits neatly within that $27 million corridor if it's a double exemption amount. And so by voluntarily imposing those restrictions, you reduce the value. And the nice thing for the rancher is, well, that's okay, because I was only and always ever planning to use the property in that way. And I plan to leave it to my children, and they'll use it in the same way. So we're none the worse for the wear. That's the idea behind it when it works well.
And so with that estate tax, because I know a lot of people that have gone through that, because it really can hit you hard if you're not careful with your estate planning and have the tools at your disposal. What are some other maybe tax incentives or tools at a rancher's disposal when they want to lessen the blow maybe on their future generations that are taking over the ranch when they pass?
Yeah. So, this is a funny number, $13,610,000. Why is it that? That's because it's attached to an inflation adjustment. That inflation, the value of assets, the value of land often outpaces inflation. And so that creates an opportunity for a rancher if a rancher is willing to transfer the asset today instead of waiting 20 years down the road when the rancher may be passing away. Then the rancher can transfer those assets at today's value. And obviously, I can squeeze more land through that $13.61 million corridor today than I can 20 years from now. I might be able to transfer half of it now. 20 years from now, I may only be able to transfer a fourth of it. So early transfers are rewarded. So if a rancher can anticipate how it is he or she would like that land or other asset to pass at death, and if the rancher is willing to make that transfer today, which sometimes involves giving up some control over the land, but if you're willing to execute that plan today, then there are rewards because you can transfer property at lower values. And in estate planning, we would call that a freeze transaction because we're essentially freezing the value of those assets today. There's an additional opportunity currently because the Tax Cut and Jobs Act of 2017 doubled the amount of the exemption. The exemption historically is higher than it has ever been. Come January 1 of 2026, that exemption amount is going to get reduced by half. Congress doesn't need to act. It's already baked in to current law. Now, there's a possibility that Congress could get their act together. Don't count on it. But if they did, they could extend it. But that would, of course, take both houses and the president to authorize that. And that's a difficult process, as we see in today's climate. So there are many folks who are saying, well, I like the idea of a freeze transaction, and right now, if I use that freeze, I can transfer up to 27 million in assets. Whereas if I wait till January 1 of 2026, that 13.61 is going to get reduced by half to roughly 7 million adjusted for inflation. And then and thereafter, all I'll ever be able to transfer if I am joined by my spouse is only about 14 million. So there is an opportunity. There is a use it or lose it element, which is baked into the tax laws right now, which suggests that that's something that you ought to consider. And if you're thinking, well, maybe I'll get around to this 5 years from now, there might just be a benefit to considering it today. Because, these are sophisticated transfer techniques. It takes an attorney some time to prepare the trusts and other documents which are needed to implement a freeze transaction. And so you definitely, you cannot call me or any other attorney in June of 2025 and say, hey, I heard about this disappearing exemption amount and I'd like to take advantage of it. Odds are there's not going to be enough time to organize your plan and implement it prior to that deadline.
Wow. That seems like a very big jump for the exemption status. Is that cyclical, or is that just the climate we're in and the inflation that we're facing right now?
Again, what happened when Trump came into office, he had a Republican Congress, and that's what they did with their political capital. One of the things they did is they doubled the amount of the exemption, but it could only be because it was part of the budget reconciliation process. And why did they do that? Well, because Congress only needs a majority in the budget reconciliation process to pass a law. Whereas if it's not part of budget reconciliation, then it requires a 2/3 vote in the Senate. And because they couldn't get a 2/3 vote in the Senate, they did it part of reconciliation. But built into the reconciliation process is a rule that says the changes which are adopted in such a process can only endure for 10 years. And then they expire automatically. They sunset. And so the Republicans said, well, I don't know what they said, but they probably thought to themselves, they'll love this so much that there will be this groundswell of support and it will get adopted in perpetuity. Well, again, could our Congress get together with the president to do something? It doesn't feel like that's a likelihood right now.
Got it. So this was kind of maybe a once in a lifetime big change that they proposed. But
I changed law firms a couple of years ago, and so I started practicing with a gentleman who's maybe 5 years my senior. So he's seen 35 years of this, and he said, Thomas, there has never been a more favorable tax planning situation in the entirety of my career.
Wow.
So that gives you some perspective as to what is possible today, if people are willing.
Wow. That's incredible. I did not know that. So we're going to definitely let our listeners and our clients know about that incentive, because that's something that ranchers, anyone who's trying to estate plan should know. And with that, I mean, we've talked about some of the tools and the advantages of maybe planning some things right now as a landowner. But another thing I wanted to go over, and something that we see all the time, is when it's a multi-generational family and there's multiple children. Some of the kids want to keep the ranch. Some of the kids want to sell it. What are some of the tools at a landowner's disposal in order to mitigate kind of that competition or those competing ideals between their kids too when it comes to estate planning?
Yeah. Well, and this is not just unique to ranchers, but it's certainly an issue to be dealt with, and that is where there's a few of the rancher's intended beneficiaries who perhaps are going to succeed because ranching is a capital-intensive operation to the majority of the rancher's wealth. But the rancher wants more than anything to perpetuate that way of life among those of his or her children who wish to continue it. And very often, because not everybody can stay on the farm, some marry and move away, and they have very different lives, and they understand that capital is needed or the generation of a livelihood for their siblings. And so often siblings will be totally fine with that. They don't need economic value to be equal across all of them. It certainly is very helpful in that setting if the rancher has had some good years and maybe salted away some savings and created some additional assets that those non-ranching children would be interested in receiving, so that they don't feel like they got the short end of the stick, or at least that they got something. And so that's where customization of the plan is important. That being said, I've, over the years, managed a few fights among families. And, there aren't necessarily easy solutions to those fights, because those fights often are not the product necessarily of someone getting more money or value or wealth than the other, but it's just the different treatment. And then basically sibling rivalry, things, issues that just kind of festered. And what you can be sure of is that while you're alive, your children more or less, if you've been a reasonably good parent, are going to want to please you. But once you are gone, they no longer have that incentive to please their parent. And now sometimes the gloves come off and children can duke it out. And what that suggests then in this planning phase is you ought to develop your plan and then use the influence you have with your children to communicate that plan to them. Your best sales pitch to get everybody on board and say, look, after I'm gone, this is what I expect to happen. And that way you've managed their expectations and hopefully no one then is surprised by what happens. Also, if you can, instead of waiting till death and having those transfers happen at death, there is an advantage to implementing those during life, because nobody can tell you to whom you're going to transfer that asset. It is your prerogative. Whereas once you're gone, someone can challenge these kind of dry, stale documents that mandate certain things should happen. And if everyone lawyers up, well, then it's a Donnybrook, right? And so anyway, giving assets that are well suited to recipients, if you have the luxury of doing that, is best. If you don't have sufficient assets outside the ranching operation, if you can acquire life insurance or something else, sometimes, even though that's very expensive in terms of paying the premiums now, it can generate a significant amount of wealth afterwards, such that the non-ranching children who receive the proceeds don't feel shortchanged. But the best time to purchase life insurance is when you're young and healthy. So again, there's the early bird benefits by planning, right?
And some of those things that you were talking about, the plans and the agreements during life. I know in some of the questions that you were looking at were the multi-generational trusts. Are those some of the tools maybe at your disposal as a landowner to have in place before anything were to happen to you?
Yeah, so one of the primary tools of an estate planning attorney is a trust. That's our pickup truck. That's our workhorse. And the idea is to take whatever assets you'd like to pass down one generation, or perhaps two or three. You want to put them in the back of your trust pickup truck and let them carry them from generation to generation. And then what you have is children getting in and out of the cab of that truck and using it for their allotted time period. And you can imagine that's really what a trust is. A trust is taking the beneficial enjoyment of assets and slicing it up into different time slots and allowing different people called beneficiaries to enjoy those at different times. And so that trust is, when we talk about an estate freeze, what we're typically talking about is taking assets such as land and putting it into an irrevocable trust, a multi-generation trust, and then allowing your preferred beneficiaries, typically the ranchers or the trust creator's descendants, to use that on an ongoing basis. Now, having said that, that sounds like a wonderful solution, doesn't it? But what happens typically with Utah families, we tend to have more children than average, and not all those children are going to have an interest in perpetuating the family enterprise. And as their wishes and desires diverge, and that's going to happen. There's just no way to mandate otherwise. And so perhaps one of the most important things is building in a mechanism whereby this whole arrangement that you've implemented, that you hope would last for as long as possible, also can be unwound without, again, everyone lawyering up and having a big fight over it. And so kind of an easy exit, so to speak. And some may say, well, I don't want an easy exit. I want this land to be used, if it's just one of my 50 grandchildren who wants to ranch, I want them to get the property, and I could care less about the other 49. You can do that, but again, it's hard to accomplish because you don't know which of the 50 is going to want to be the rancher. And so anyway.
It's a big undertaking. And that kind of brings up another question. Are there any benefits? Because we handle a lot of clients who come to us who want to sell the property because maybe they don't want to go through the process of planning, estate planning and leaving it to their kids because maybe they think this is going to hurt their kids more than it's going to help. Is there a benefit to maybe leaving it in the family versus selling it to a third party? Or is it just dependent, again, on, the people at play?
Yeah. So there are clearly benefits to transferring now, as we've already described. But there are certain tax considerations that go into that. And one is when you make a gift of property during life, the recipient receives a carryover basis in the property. So property is a capital asset. If you sell it, the way we tax that sale is we look at the amount realized upon sale. We subtract from that whatever your tax cost basis is. Tax cost basis, these are terms of art, but it really just means what you paid for the property. And then you get to depreciate maybe some of the improvements on the property. So that value of the property, the tax cost basis goes down, but then you build a new barn. So there's some additional improvements, and then that goes into increasing the tax cost basis. But when you sell it, it's amount realized minus tax cost basis, and then we pay a capital gains tax on that. Well, obviously paying a tax today is much worse than paying a tax tomorrow. And it's possible that if you don't transfer the property, that you'll never pay tax, or at least you won't up until on any appreciation that occurred up until the time of your death, which means that at death, if you own an asset such as your ranch, you get a step up, a free step up in the fair market or in the tax cost basis to the fair market value. What does that mean? I bought the ranch for $20 million. It's now worth $50 million. My children will inherit that with a $50 million tax cost basis. If I own it at my death, they could turn around and sell the ranch for $50 million and not pay any income tax whatsoever because of that step up in basis. So there's this tension. There's this idea, well, if I own it till I die, I can avoid any capital gains tax on the appreciation of the property while I've held it. Yes, you can sell it now, but you're locking in a tax that perhaps might have been avoided had you held it till you die. But certainly if you sell it today, your kids can't fight over it because what you'll receive in exchange is cash. Cash is fungible. If there are $2 here, I don't care which one you receive, Hayley, and which one I receive. Either one spends just the same. It's fungible. So there is an advantage I guess, I suppose, to avoiding family fights by just having cash at the end of the day to divide up.
Got it. And another scenario, and something that we've seen in the past, or we've had questions from clients, was okay. Let's say, I sold a company, I have all this money. I'm maybe 10 years from retiring, and I'm considering estate planning and where I should put these assets. The stock market, all these different things. What's the benefit if I were a buyer of land for my kids to put that money into maybe a couple different properties and give those I don't know if that's a scenario you run into, but
Yeah.
those have been questions that our buyers have had before.
So as an attorney, I try not to give investment advice because that's not what I do. But I understand a little bit about it. I loved my finance classes in accounting school and MBA school. And obviously, land is a diverse investment from the stock market. And so any investment advisor would suggest to you that it's good to have a little bit of real estate in your overall investment portfolio. Now, land tends to cost a lot of money. So often people who buy a ranch tend to be real estate rich and other investment poor. It tends to occupy more of their portfolio than a typical investment advisor would recommend as being healthy. But many people sleep better owning land. My wife keeps telling me, Thomas, we should get out of your 401k and go buy some land somewhere. She just likes the sound and feel of that. And she grew up in Grantsville where they ranch sheep. That just makes sense to her. But in any event, if you're sitting on a lot of cash, you ought to deploy that in a way that makes sense. And having a good investment advisor help you do that is recommended. And certainly part of that can be investing in land. And then there's also the aspect of personal enjoyment on the land, depending upon what kind of property you buy, that adds to your intrinsic happiness, separate and apart from investment returns.
Mm-hmm. Well, once you do, empty your 401k, Chris is there to help you guys with your
Awesome.
Utah ranch search. And beyond kind of, the different benefits and all these things, what are some of the things that our clients should look out for? What are the mistakes that you've seen made from an estate planning perspective when it comes to ranchers or landowners when they start to go down this path?
Yeah, probably the biggest mistake is to not plan at all.
Yeah.
Unbeknownst to all of us, we all have a will. The Utah state legislature adopted that for us, and it's the same in all 49 other states. And that means that it's going, if all my children in Utah, if all my children are also my wife's children, then everything goes to my wife if she survives me. Otherwise, it goes to my kids. If one of my children should predecease me and leave two surviving children, my two grandchildren, then that deceased child share would go to those grandchildren. We call those the laws of intestate succession. Intestate just means dying without a will. So if that doesn't reasonably approximate what you would like to have happen with your assets, then you ought to have a will. You ought to do your planning. And so the mistake is to not to plan at all. There are many who feel, oh, those attorneys, they're slick, they're sneaky, and they're expensive. I heard that you can just own property as joint tenants with right of survivorship, and the property automatically passes to the survivor. And I would say you are right. If it just so happens that your spouse survives you, and that's who you want to receive the property, you have scored a victory, if you will. But if you die in a common accident, well, then what? Well, joint tenancy doesn't speak to that. There are other forms of common ownership, tenancy in common, which has a different impact. There's no survivorship benefit in a tenancy in common. If I die, now one half of it is owned by my estate and the other half is owned by my wife. So these, what I would call a poor man's will, joint tenancy is not the solution that it first presents itself to be. And being a little more intentional, a little more purposeful, a little more aware, of your own circumstances and what you want to have accomplished, that's rewarded. The second thing is maybe you went out and you got your estate plan back when you had kids. Your wife nagged you to do that because she was worried if you went down in a plane crash, who would care for them. But your circumstances today are very different. And yet you haven't updated that plan in 20 or 30 years. That's also a huge mistake. Sometimes people will have a plan, but they won't follow through with the plan. Even though it's a good plan, they don't transfer assets like the attorney recommended to the trust, or often, they can leave their survivors in a mess if they fail to equip the survivor with the tools that are needed to access those assets. So many of our assets now are protected by passwords. Well, how do we keep track of those passwords? And do your successors have those passwords so they can gain access to those assets? And then I guess there are lots of mistakes you can make, as you get into sort of this sweet spot of in your 60s, and maybe you're developing your succession plan. And that plan is only, we talked about earlier, the benefit of sharing that plan with your children so that you've managed their expectations. Well, you want to do that at just the right time, because some kids will say, like the prodigal son, well, okay, you've spelled out what my inheritance is, Dad, give it to me now. And all of a sudden you're having a conversation you never really wanted to have, and you can't pull that back. So if all of us could predict accurately when it is we were going to pass away, if I was going to pass at age 73, then maybe when I'm about 70, I'd want to start having that conversation.
Right.
But in any event, having that conversation at the right time is a good thing, and having it at the wrong time can be a mistake. Maybe the last thing is just choosing the people who are going to be in charge carefully. You can make some mistakes there. Those people that you might identify now perhaps are not going to be the same people you would identify in 5 years. So again, that gets back to updating that plan. The person who carries out your plan, that person needs to have their game on. They need to speak for you. They need to have a good rapport with everyone whose interests are going to be affected. Again, people just, often that's people's kids, and sometimes someone will work himself into a pickle. He has a hard time at work, he develops a drinking habit, and all of a sudden he was your best shot, but now he no longer is, and you need to make a change to make sure that. Anyway, those are some of the things that can go wrong.
No, that's great advice. I wish a lot of our past clients had listened to you before doing some of the decisions they made. But no, this is incredibly helpful, Thomas. And I know we've taken a lot of your time today. For those listening who do have questions, what are some of the things that they can do, or the resources maybe Holland and Hart has available to some of the clients or buyers that are out there?
As I mentioned before, these plans are not something that we just try to unload in a cookie cutter fashion. We want to get to know you. So if you were to do planning with us, our first step is to send a questionnaire to you that invites you to tell us about your family relationships. There's a couple pages on what your goals are for those family members, and we invite you to list your assets and what it is you want to have happen with those assets. And so that's how you would begin working with us. It probably would be beneficial to do some research beforehand. And in preparing for this podcast, I went out on the internet to just kind of see what is available. And a couple of resources that I thought were quite good. Iowa State University put together an estate and succession planning for the farm. And then Colorado, a guide to planning for the future of your farm. These are both, 50 pages, much more detailed than what we've gotten into in this brief discussion. And you're going to read over that and your eyes are going to glaze over and you say, why does this stuff have to be so complicated? But if you'll spend just a little bit of time with it, and then you hire a good attorney who can be a good interpreter for you, trust me, it's not terribly complicated. We lawyers, like doctors, we use fancy specialized words, and we do that because they have particular meaning to us. It's a way that, and there are probably vocabulary words that ranchers use that would leave me dumbfounded. I would have no idea what they were talking about. I've never birthed a calf or whatever else it is. And so,
Believe me, I haven't either.
so, but in any event, I think getting familiar with some of these concepts and principles, and then meeting with a good attorney who will listen to you and help you execute your ideas, that's I think the way to go about it.
That's great. And I can't thank you enough, Thomas, for taking the time. Chris speaks very highly of you. And listeners who are listening to this or watching, estate planning is incredibly important. We've handled a lot of transactions with families who've maybe the dad or the mom has passed away, and it really can pull apart a family in a lot of ways. So it's very important to have these things handled beforehand so you can retain those relationships, take care of the ground, be stewards for generations if that's a choice. So this is a really good first step. So for more information on estate planning for ranches or the ranch marketing process, please be sure to give us a call. And thank you again, Thomas, for joining us for the Land Bulletin today.
It was a pleasure, Hayley. Thank you.
Thanks for joining us today. To learn more about the ranch real estate market or our ranch marketing process, make sure to subscribe to our newsletter on our website at merranchgroup.com or give us a call at 303-623-4545. See you next time.